For what purpose does the gentleman from Arizona rise?
Have amendment at the table.
Clerk will designate the amendment.
Amendment number 5, printed in House Report number 112-416, offered by Mr. Gosar of Arizona.
Pursuant to House Resolution 591, the gentleman from Arizona, Mr. Gosar, and a member opposed will each control 5 minutes. The chair now recognizes the gentleman from Arizona for 5 minutes.
Madam Chair, I rise to address the House today in support of my amendment to H.R. 5 to amend the McCarran-Ferguson Act. This act exempts the business of insurance from many federal antitrust laws. In this modern day and age, it is hard to see why this exemption still persists. One of the original reasons to carve this exemption for the industry dates all the way back to 1945, was that insurance companies needed to share actuarial information in order to balance risk when setting premiums. However, since 1945, our federal law has evolved to include safe harbors to permit companies to share this data as needed. I believe that violations of antitrust law cannot always be dealt with on the state level anymore, as cash-strapped states lack the resources to enforce the law against these large, multi-state insurance companies. Therefore, it is time for this exemption to be repealed so that we can empower health insurance companies to compete more aggressively for the consumer dollar. Increase competition, increase insurance options, empower patients to a patient-centered system, and they decrease premiums. Therefore, we all win. Lowering the cost of health insurance is a goal we should all share, and that is why the House passed a very similar measure, H.R. 4626, with over 400 votes in 2010. There is one key difference between H.R. 4626 and this amendment, a difference of which I am proud. My amendment includes a prohibition on class action lawsuits in federal court against these health insurance companies. The FTC should have the power to investigate bad actors in the health insurance industry, but it helps no one if these companies, or for that matter, any American businesses, get mired in lawsuits that will cost millions. Class action lawsuits often result in big bucks in attorney's fees for greedy trial attorneys while leaving only pennies in the hands of plaintiffs who are allegedly wronged in the first place. For example, let's take the Cobell settlement. 15 years ago, a group of Native Americans sued the federal government and Secretary of the Interior Bruce Babbitt for mismanagement of their funds and won a $3.4 billion settlement, only to find out that their attorneys were petitioning the judge for over $200 million in fees. This is outrageous. When the poorest of poor are wronged in this country and are awarded a settlement in court, they shouldn't have to split pennies amongst themselves as their lawyers walk away with a big fat check. That is the spirit behind the tort reform piece of my amendment. I am pleased to see this House ready to pass a significant tort reform today and encourage all my colleagues to support my amendment as well as the underlying bill. Thank you again, and I reserve the balance of my time.
Gentleman from Arizona reserves. The gentleman from Michigan.
Madam Speaker, I rise